Hello, welcome once again. Today's video is still on our discussion on classification of trusts, and today we are making a little progress to discuss another classification. In the last video, I discussed the last aspect of express private trusts, which is the three certainties of express private trust. So let's proceed to look at another class of trusts, and the one we are looking at today is charitable trusts. Charitable trusts or public trusts, that is express public trusts. Express public trusts. So whether you call it public trust, more often when reference is made to a public trust, you are actually referring to express public trusts, but it is commonly regarded as charitable trusts. So in this video we are to look at what trust can be regarded as charitable. What are charitable trusts is what we are to look at, and the various classes of charitable trusts. So let's go. So what is charitable trusts? In the previous video regarding the general overview of the classification of trust, I actually mentioned that public trusts or charitable trusts are those trusts made for public benefits, which has a charitable purpose. But the definition of the word charity or charitable is not that easy. So when you use the word charity or charitable trusts, then defining it becomes a problem. So the first point is about the problem of definition. The problem of definition of the word charity or charitable. So the court have had difficulty in defining and determining what can be considered as charitable trusts. There have been difficulty in defining and determining what constitutes charitable trust, or in defining the word charity, because in law the usage of word is usually different from its common usage. So in a common usage, charity or charitable is anything that is done for the needy, any benevolent acts that is done to assist the needy will constitute charity. But legally, what might be commonly seen to be charitable or charity may be held to be otherwise, because perhaps it may not satisfy some of the legally required elements of what constitutes charitable trusts. So take note that there has been a problem of defining and determining what is charity or what can be regarded as charitable. However, there was a kind of penmanship to the problem. Fortunately, there was a particular statute that had helped the court in resolving this problem. The relevant statute is the Statute of Uses Act. The Statute of Uses Act, also known as the Statutes of Elizabeth 1601, has come to the aid of the court, did not leave us in this stream of uncertainty as to what constitutes charitable trust. The act serves as a guide, in that the act in its preamble contains some list of objects, some list of trusts, some items which assist the court in determining what is charity or what is charitable trusts. That is how useful this act is in respect to determining what is charitable trust. So the act contains some list of objects which are charitable or which can be considered as legally charitable. Therefore, any trust that falls within the words, the spirits, and the intendments of the Statutes of Elizabeth is considered to be charitable. So the point I'm trying to make is that there have been difficulty in determining what is charitable trust or what is charity. However, a statute had helped us or had assisted the court in resolving that problem, and the statute is the Statutes of Elizabeth. That in the preamble of this statute, there are some objects that if a particular trust falls within the intendments of that statute, of those, or fall within the words, the spirits of the items listed in the preamble of this statute, then it can be considered as a charitable trust legally. It can constitute, such trust can constitute a charitable trust. Furthermore, this Statute of Elizabeth, take note that subsequently was repealed. So the Statute of Elizabeth was repealed by the Moatman Act, by the Moatman and Charitable Uses Act. So the Moatman and Charitable Uses Act repealed the Statute of Elizabeth. However, the preamble that contained the list of items that guide the court in determining what is charitable trust was fortunately preserved. So the preamble was preserved and it still served as a guide to the court. In my opinion, perhaps it is because of the usefulness of that preamble in determining what is charitable. That was why it was preserved, despite the act was repealed. So now let's look at the list of items, some of the list of items contained in that preamble of Statute of Elizabeth. Example of list of items or list of trusts which are contained in that preamble and that can be considered to be charitable are trust for the relief of aged, impotent, and poor people. So any trust that is for the relief of the aged, impotent, and poor people, according to this Statute of Elizabeth, can be regarded as charitable trust, or is a charitable trust if such trust is for that purpose. Also, trust for the maintenance of sick and maimed soldiers and sailors. So any trust for the maintenance of maimed soldiers and sailors is also a charitable trust. Another item in that list is trust for the maintenance of schools, schools of learning, free schools, and scholars in universities. So any trust for that, according to the preamble of Elizabeth, is legally charitable. It's legally charitable. Another one is trust for the repair of bridges, ports, churches, and highways. So any trust for this purpose is charitable. And the education of orphans. So and so on and so forth. The list is not cannot be exhausted here. But those are some of the things contained in the preamble, and any trusts for that purpose is legally charitable or can be considered as charitable trusts. Now, this particular list is not longer the one guiding the court today. The list contained in the preamble of Statute of Elizabeth has been considered to be archaic and also inexhaustive. So there is now a new classification of charitable trusts, and the new classification was propounded by Lord Macnaghten. Lord Macnaghten, in the case of Commissioners of Income Tax versus Pemsol, that was where another list of objects which can be regarded as charitable, or list of trusts that can be regarded as charitable trust, was laid down, was stated and outlined by Lord Macnaghten. So this is now the new list that guides the court. So any trust now which fall within the categories listed by Lord Macnaghten is a charitable trust. And the classes of charitable trust propounded by Lord Macnaghten is 4. So there are 4 aids of items or trusts which can be regarded as charitable. And what are they? One is, number one is trust for the relief of poverty. Trust for the relief of poverty, that's number 1. Number 2 is trust for the advancement of education. So if a trust is for the advancement of education, then it is charitable. Then number 3 is trust for the advancement of religion. So any trust for the advancement of religion is charitable. Then number 4 is any trust that is beneficial to the community, which come within the word or spirit of the preamble of the Statute of Elizabeth. You can see that the Statute of Elizabeth is still useful. For instance, now this number 4, which is other purposes beneficial to the community, that aid now is like an omnibus aid. So every other purpose now can fall within that category, provided it is beneficial to the community, and also fall within the word or spirit of the preamble of Statute of Elizabeth. So the Statute of Elizabeth is still relevant with respect to this number 4 category propounded by Lord Macnaghten. So the next thing is for us to briefly consider these various aids. I shall end this video by looking at trust for the relief of poverty. Trust for the relief of poverty. Then in subsequent video, we shall look at the other 3 aids. So when is a trust said to be for the relief of poverty? What trust is a trust for the relief of poverty? And the first thing to look at now is what constitutes poverty. Who can be said to be poor in order to be entitled to a trust for the relief of poverty? The 4 before stating that, take note that there are some requirements for the validity of charitable or public trust, which we shall consider subsequently. However, at this point, it is important for you to know that trust for the relief of poverty is an exception to that requirement. So if a trust is for the relief of poverty and it does not fulfill those requirements, for instance, one of the requirements is that for a trust to be charitable or public trust, it must have a public benefit element. But for trust for relief of poverty, even if it does not have this public benefit element, it will still constitute a charitable trust. So trust for the relief of poverty is an exception to the requirements for charitable trust. Take note. Now, what constitutes the word poor for trust for the relief of poverty? Well, there is no any precise definition, but what is important is that to qualify as poor, the beneficiaries of that trust need not to be destitute. There's a debate that can be said as to trust for the relief of poverty. So who constitutes a poor person with respect to poor for the relief of poverty? The important point, or what can be said, is that for the beneficiaries need not to be destitute in order to for them to fall within the categories of poor persons. So they need not to be poverty stricken or suffering extreme poverty. It is sufficient if they are in need. So if the beneficiaries are in need, then such trust is valid or can be said to be trust for the relief of poverty. Then the next point you should note is examples of trusts that have been held to be trust for the relief of poverty. That's the next important point. And in noting those examples of trust, you must also know the cases in which they were held to constitute a trust for the relief of poverty, which by extension is a charitable trust. So there are some cases and some trusts that have been held to be trust for the relief of poverty. I think the one I can still recall is still upstairs here. Trust for ladies of limited means. So trust for ladies of limited means have been held to be a trust for the relief of poverty, and that was the case of rigadom. So in respect of gadom, in the case of rigadom, trust for ladies of limited means was held to be trust for the relief of poverty. Then also trust for the relations, for the poor relations of the donor had been held to be trust for the relief of poverty. In the case of Riscarisbricks, trust for the poor relations of the donor was held to be trust for the relief of poverty. Then permit me to see other lists from the material here with me. Other lists of trust that have been held to be trust for the relief of poverty. Another example of trust is trust to provide flats at economic rent for aged persons have been held to be a charitable trust, and that was the case of Ricotam. In Ricotam, that was where it was held. Then another example is trust for the encouragement of poor immigrants. So trust for the encouragement of poor immigrants was held to be a trust for the relief of poverty. In the case of Basley versus Masclean, that was where trust for the encouragement of poor immigrants was held to be a trust for the relief of poverty, and by extension a charitable trust. So the list continues on and on. But what is important, you just need to know, for the purpose of exam, you just need to know some of them and the illustrative cases. So we'll end the study here and continue in subsequent video. Thanks for watching, and don't forget to do the needful. Subscribe.